FM. That's the Wall Street Business Network, and from 7 to 9. And matter of fact, we have Beth West and Tom Bone in studio live this morning. Yes, it's Easter weekend, but they are live, making that sacrifice, getting in here. And they're also going to be on Monday morning, coming up, this coming Monday, at 8 o'clock. You'll be on again from 8 to 8:30. So if you have any questions, you weren't able to call in this morning or email, here's a second shot at it coming up Monday from 8 to 8:30 a.m. So again, welcome to the second segment, Tom and Beth. So let's get right into it, because I know time flies, when we're having fun, like this. So
absolutely, and I'd like to share a couple examples of how employers using their gut can get themselves into potential trouble or trouble. And Beth may have some comments regarding these examples. One is an employer that's been in business 20-some-odd years, and he has the view that when you get 65, I just learned this recently, that it's time to get the golden watch, and out the door you are. And since some of us are around that age, I kind of resented that a little bit.
Yeah, speak for yourself, Tom.
That's right. You're my younger cousin here. That's correct. I forgot about that. And we went through this dialogue with him on some other issues, and he brought this up, and I said to his name is Wayne, and I said, Wayne, please clarify that. He said, well, this is what I plan to do, because, these older people, they get hurt, and it's very labor intensive in our truck repair business and so forth. And I said, well, Wayne, we need to bring someone in to review your employee manual, how you handle these type of situations, and please, at this point in time, don't fire the person. He said, well, I'm glad you mentioned this, because I'm having a meeting with him on Friday, and this was about a couple weeks ago. He said, I'll go ahead and defer that. Well, there he had some premonition, some idea that was okay. The productivity of the individual was slowing down, and so he's turning 65, so let's just move him out and bring some young buck in.
Well, I think your advice to him was very good, Tom. Very good indeed. He needs to come to one of our seminars at SEAC, obviously, because there is protection for employees over the age of 40. I do have to say, even if you're 40, you're considered old, both federal and state law. That would be the Federal Age Discrimination in Employment Act, and then the California Fair Employment and Housing Act. Both consider age a protected activity, and therefore any kind of adverse employment action cannot be taken because of age. Now, that's where it gets tricky, because there may be other reasons in which there may be a bona fide reason to let older employees go, but not because of age. If they can still perform the essential functions of their job and aren't creating any other problems in the workplace, aren't violating policies, then they should be able to continue to work just like any other employee. Courts don't like to see employers be too paternalistic. They don't want them to say, well, if you're getting older, maybe, you're more at risk to get injured, especially in manufacturing kind of environments and that kind of thing. So that was very good advice, and I think that Wayne should contact an employment lawyer like myself, or attend one of SEAC's seminars.
Beth, I have a quick question for you, and I don't know if I'm right or wrong on this, and that is, being a small business person, I don't know anything. But anyway, does the number of employees that you have something to do with this? In other words, I've heard that if you have less than, I don't know what it is, I'm going to say 20 employees, that you're exempt from some of these rules.
Yeah, that's a great question, Mark, because actually most statutes do have size requirements with respect to whether an employer is covered. Unfortunately, they're not all the same. So, for example, California's Fair Employment and Housing Act, if you have 5 employees or more, all of the non-discrimination, non-retaliation rules under that act apply. And as a matter of fact, the prohibition on harassment in the workplace applies to any employer, even if you just have one.
Oh, wow. So there's some gray areas there.
There's gray areas. Then there are various other laws, mandatory leave laws and things like that apply to employers with just 25 or more employees. The federal laws, Title VII, which is kind of the civil rights provision, preventing discrimination. That applies if you have 15 or more, as does the Age Discrimination in Employment Act. So it really depends on the statute and the, the issue that you're dealing with.
Mm-hmm. Okay.
have another example. It's in a little different industry. It's more retail-oriented, and it just so happens that we got to the situation a little too late, but we were helping them maneuver through the process. The scenario is basically there's a manager running a retail business for this multiple location organization, and she's the manager, and the scheduling and the bookkeeping for that particular location wasn't being handled as far as the owner was concerned appropriately to get the data to properly manage and reports were late and so forth. And it so happens that this manager got hurt on the job. No one saw it, but she slipped and fell on her back, and so she had lower back pain and so forth. My client said to me and also their in-house HR person, I no longer can tolerate working with this individual. And we all advised her, this is not the right time when the person's on workers' compensation benefits. Irregardless of how you feel, let's find some ways by which we can work with the situation until there's an opportunity and you have appropriate legal counsel. Appropriate legal counsel, really critical in these kind of situations that are very, very touchy. Let's go ahead and move forward. Well, a week or so later, I get an email from the HR person says, you'll never guess what happened. This person's been terminated. Well, weeks go by. And sure enough, the lawsuit is tendered to my client, and $100,000 later, it's his history. Wow. And, again, emotions got involved. We have an entrepreneur that this is, like you say, Mark, this is my business. I'm excited. I have the independence to do certain things, and my gosh, we overreacted. And we weren't listening to those advisors around me to try to help me run my business better.
Mm-hmm. Yeah, those are very delicate situations because, as I understand from that, story you just told us, that fact pattern, there were performance problems. And I have to tell you, I'm a defense lawyer, so I represent businesses and employers. Sometimes those injuries or those stress claims or those claims that all of a sudden they've been subjected to a hostile work environment come very closely on the heels of very bad performance because they know something is coming down the pipeline, right? So not to say that there aren't valid claims, there are. But in that situation, if the employer documents those performance issues, there's tangible, objective evidence that the person is not performing up to expectation, then they have a legitimate reason to terminate the person that is not related to the workers' comp claim. It's not because they filed a workers' comp claim. Now, but it's always very tricky because the timing of the termination while the person's on workers' comp, just on the proximity of time, oftentimes the employee will say, well, the stated reason that the employer is terminating me is really pretext. And the reason why they're terminating me is because I filed workers' comp. So it really does, it's very case specific. It's very fact based. But I never want an employer to think that when somebody goes on some protected leave or files a workers' comp claim and is engaged in protected activity, that employee has a get out of jail card, free card, and has more protection than they would have if they hadn't done that, because you get to take disciplinary action against employees who don't perform up to expectations, who violate policy, even if they've engaged in protected activity. But you do have to be very careful in doing it. You shouldn't just do it willy-nilly.
A question, and this probably would go to Tom here, is that this is Tom Bone. You can reach the show at 1-888-923-1380. There's insurance for this, isn't there? The idea is that I can see small business people cringing in their boots, out there, probably cringing in their tennis shoes. But the thing is they think, oh my gosh, I can see it now. I got to get rid of this employee. They just are not working out. And if I don't do it exactly right, I'm going to get sued. And even though I win, I'm still out $100,000, out here. And is there insurance that covers that, like an E&O, type insurance, but for employment with this kind of a lawsuit, Tom?
Yes, there is, and it's called Employment Practices Liability Insurance, and it's really a funding mechanism to pay for Beth's services and her team of specialists that help you navigate through the problem. So it's a way to pay for these potential problems on the installment plan, so to speak.
Okay,
it's very reasonably priced.
Okay, that was going to be my
question. As a matter
of
perspective, how one feels. But Go ahead.
Well, probably in tune with that too, since somebody might be insured through you, let's say for this kind of insurance, that they've got on tap some good advice too. So if they're really contemplating now letting someone go, they're going to be in touch with you because you're going to also want to protect yourself on an insurance claim and give them some good advice.
Well, all these programs, insurance programs now, are really like service arrangements where they provide the helpline, the consultation. They work with people like Beth and others before this decision is made and before the person is terminated, so that Beth and her staff can navigate them through the system. And it's really key, working through the system as best you can instead of just following your gut and making a decision that might be harmful.
Yeah.
And that's the whole reason why we're here, and thank you for letting us promote
this It's good
program.
advice, Tom.
Yeah, and I would say that with respect to that EPL insurance, certain things cannot be insured against. So there are some exclusions there that actually come up quite a bit in the employment arena. So employers should be aware of that as well.
Okay, Beth, we're going to have to cut, on it. We got to go to break, but I want you real quickly give your numbers out and your company, real quick.
Okay, Beth West. I'm with the law firm of Weintraub, Genschel, Chediak here in Sacramento. My office line at work is 916-558-6082.
And I'm Tom Bone with ISU Insurance Services here in Sacramento. And of course, it's 916-265-3837.
Great information, Beth and Tom. And again, you're going to be coming up on Monday on the Money 105.5 show, and you'll be up at the 8 o'clock hour, I believe it is.
8 o'clock.
Yeah. And we'll see you Monday. Same information, but people can call into the show at that time, too, if they've got some questions. So thanks again for coming in, and we'll be right back. I'm Mark Montgomery on Small Biz Talk Radio.